Welcome, everyone. Thank you all for coming tonight. My name is Rachel Salcido. I'm a professor here at McGeorge and the Associate Dean for Faculty Scholarship and Diversity Initiatives. What brings many people to law school, maybe some of you, is a deep desire to help others, to stand up and provide a voice to people who feel that they have no voice. And I hope this evening's program will kindle that spirit in all of us. Among other recent events, the white nationalist rallies in Charlottesville, Virginia, raised concern that the U.S. is experiencing a resurgence of white supremacy, and that this movement is becoming normalized among a larger segment of our population. And tonight's distinguished speaker event is intended to provide lessons for lawyers and all members of our community from the controversial history of the Nazi legal regime. The aim of the program is to promote a stronger community committed to ensuring equal protection of the laws and preservation of the rights of minorities against forces of oppression. Before I introduce our distinguished guest, who actually has been to McGeorge before, so before I welcome him back to McGeorge, I wanted to give a couple of thanks. First and foremost to Professor Julie Davies, whose idea it was to have this program and who extended the offer and invitation to Justice Fybel. I also want to thank Professor Carrie Bricker of the Diversity Affairs Committee and all of the students who have been working really hard to promote this event. Of course, we can't do any of this without our McGeorge internal team, including Cassandra Fernandez, and I'm not going to find people. I need Stevie Sparks, who's over here, Sandy Griffith-Reed in the back, people who aren't here, like Bethany Daniels and Mary Economy, who helped with promotion. And I just think it's so important to have great people who are willing to go the extra mile to make sure that these programs are terrific. So thank you all. It is now my pleasure to introduce Justice Richard Fybel. Justice Fybel was born and grew up in Southern California. He's from California. That makes me so happy. He's got both an undergraduate and graduate degree from UCLA. So his people were gasping. With delight, I hope. He was on Law Review and graduated Order of the Coif. He has a very long and distinguished biography, but I've just picked a few things to highlight about Justice Fybel today. He was confirmed as an Associate Justice of the California Court of Appeals, 4th District, Division 3 in February of 2002, and before that time, he was a judge of the Orange County Superior Court, where his assignments included both criminal and civil cases. Since 2004, Justice Fybel has been the chair of the California Supreme Court's Advisory Committee on the Code of Judicial Ethics. He's an advisor to the Commission for the Revision of the Rules of Professional Conduct of the State Bar of California. He was the chair of the California Supreme Court Committee responsible for recommending the structure and rules for the Supreme Court Committee on Judicial Ethics Opinions. As you can probably tell, Justice Fybel knows what he's talking about when it comes to civil liberties, ethics, and civility, which he has written and spoken about extensively. We are honored to have him here this evening to speak on one of his areas of expertise. And the topic of his presentation is it already up so I can just point to it? From the absence of judicial ethics to justice, the Nazi judicial system and the Nuremberg Trials. He says he's throwing that in for us as a bonus. Please join me in welcoming him here tonight. Justice Fybel will speak for about a little over an hour, and we have passed out comment cards, so if you can write down your questions and pass them to the center where Professor Bricker is, we will sort through those and ask them at the conclusion of his remarks.
Thank you very much. Thank you all for coming. It's hard giving a speech with nobody here, so I really appreciate the turnout. I want to thank all the people involved in organizing this. From my standpoint, I've worked a lot with Dean Salcido and with Stevie Sparks, who've been a terrific help, and of course Julie Davies, Professor Davies, whose idea this was in the first place. I should tell you that Professor Davies and I started working together back in the 80s. We worked at Morrison and Forster together, and so we've known each other a very long time. I take full credit for all her success. I just want you to know that. And I've already had some very nice conversations with some of the students here, and I do want to congratulate Dean Schwartz on his new appointment and wish him all the best. And I want to let you know, my wife of almost 50 years is here. Susan is up there on the gallery. So I want to step back before I start sort of the formal part of the presentation and give you sort of the view from 30,000 feet, which is in Germany in the 30s and early 40s, all of the country's institutions, every single one of them, failed to protect human rights, liberty, and indeed life itself. I should ask you, can you all hear me okay? Okay. So just reviewing those institutions, when you think about what does society depend upon to uphold its own values, these failures included judges, the judiciary, the legislature, the universities, the law schools, in fact, every professional school, the religious institutions, the military, and the press. So when you look around and try to say, well, who is going to save people from destruction of human rights, those are the institutions that are typically looked to, and every single one of them failed. I've thought about a lot on how to start a presentation like this with law students. And I've had some experience in this regard, so I'm going to try to do what I think was successful in the past. And I'm going to ask, if I get a volunteer, that's great. If not, I'll give you the answer. But if there is somebody that wants to be brave, that'd be fine. But if you're thinking about a judge or the judiciary as a whole, what qualities or values do you think make a successful judge? If you're appearing before a judge, what do you want that judge to be? What kind of values and qualities do you want to see a judge have? Any volunteers? Yes.
Independence and fairness.
Okay. Independence from what?
From extraneous forces outside the matter that's being decided.
Right.
And fairness with no preconceptions, but being fair to both sides and deciding on the facts and law.
Well, you hit a grand slam home run, so she's not a plant at all. So here's the thing. There are three, sort of, in my view, fundamental characteristics, and you've hit them all. The first is impartiality. That is fairness. You want every case decided by a neutral person who is just basing the decision on the facts of that particular case, not prejudging it one way or the other. That everyone who is a party to the case is going to get a fair hearing, going to feel like that person has been heard and before an impartial person. The second, independence, and of course, people talk about the independence of the judiciary all the time, but they never say independent from what. And again, you're right. It's independence basically from politics. It's basically independence from outside sources. That you don't have the executive telling you what to do. You don't have the legislature telling you how to decide the case. Yes, you're interpreting legislative acts, and you're sometimes interpreting executive action, but they're not telling you how to decide the case. You have to decide the case based on the facts and the law and justice in each individual case. And the third, and it kind of goes with impartiality, but it's very important in sort of this lesson, which is the absence of bias and the absence of discrimination. That is, the neutral or impartial judge is not going to decide against you because of your gender or your religion or your sexual orientation or anything else that's extraneous to the actual merit of the case. So it's a lack of bias and a lack of discrimination. So those are the sort of the qualities at least that I think are key to a successful judge. I'm one of the 4 authors of a new treatise that's coming out in about, well, within the next 30 days on California judicial ethics. And we had to step back and say, okay, so now we've got these really great characteristics. Is there some central theme that we can gather and attribute to these characteristics? And what we've come up with really is the integrity of decisions and the decision-making process. That is, that a party going to court knows that there's integrity to each decision and an integrity to the process itself. That is how a decision is being made. And in terms of the qualities of a good judge, beyond knowing the law and researching the law and that type of thing, and these other things, impartial, like a bias, independence, there are 2 qualities. One might say they're 1 quality, but there are 2 qualities that none of these judges that I'm about to talk about had, that we've concluded is a requirement. And that's empathy and basic decency, basic human decency. So with that background, I want to talk about the subject, which is the Nazi legal system, 1933 to 45, and then I'm going to conclude with sort of the bonus round of the Nuremberg Trials. So as Dean Salcedo mentioned, I've been the chair of the Supreme Court's Advisory Committee on the Code of Judicial Ethics. We advise the court on what the Code of Ethics for California state judges should be. And because of that, in my own family history, I became interested in the Nazi legal system. And because I asked myself, how in these years before and during World War II could all these rights have been so destroyed? My parents were refugees from Eastern Europe. My father escaped Germany in July of 1938. My mother escaped Lithuania in March of 1939, which, if you know your history, means barely in time. Over 95% of the Jews in Lithuania perished in the Holocaust. So she got out by some miracle. Both of them made it safely to America. They met in Los Angeles, married and raised a family. Obviously, millions of others did not get out of Eastern Europe. So what I'm going to do is give you an overview of the Nazi system, the legal system, with emphasis on the judges, the judiciary, and the lawyers. And then I'm going to conclude with discussion of the Nuremberg Trials, not just the main Nuremberg trial, which you may be familiar with, but also the trial of the judges, because there wasn't a separate trial of Nazi judges in Nuremberg after the main trial, and I want to talk about that. So I asked myself, how are millions of lives destroyed and freedom stolen as an official policy of a civilized country in Western civilization in the 20th century? The chilling core message, which you'll see develop through this, is everything the Nazis did in their legal system was legal, in quotes, under their system. So I want to start out with talking about, chronologically, the anti-Jewish laws, because they actually had laws. Starting in January of 1933, they had a civil code. It had been enacted in 1898. They had a well-established legal system. Hitler was the legally appointed chancellor. The Nazis themselves recognized the importance of written law. In fact, they said that written law was the source of state authority. They acted in their own words within the framework of traditional law. Basically, the anti-Jewish laws that were passed enabled the state was essentially the Nazi party and the police, to ignore individual liberties. In February 1933, President von Hindenburg, who was still alive and who was a hero of World War I, and Chancellor Hitler issued an emergency decree, and it was called for the protection of the people and the state. One of the things you'll notice, all of these decrees and laws have these very highfalutin names to them. What did the decree do? It suspended sections of the Constitution that affected freedom of the press and individual rights. But although all these rights were in suspense, Germany still had a constitution. But the constitution itself permitted itself to be changed by a 2/3 vote of a quorum of the Reichstag, which was the legislature. The enabling law of March of 1933, see how early this is. This is March 1933. This passed the legislature and empowered Hitler to enact legislation deviating from the Constitution for 4 years. So obviously, if you tell someone you can deviate from the Constitution for 4 years, that's pretty much, that's indefinite. I mean, you're never going to, at the end of 4 years, no one's going to stand up and say, excuse me, your 4 years is up. So basically, the Reichstag voted itself out of existence at that point and gave Hitler dictatorial powers. And this all happened, so the point I'm about to make is all these things happened really fast and really early. In March of 1933, there was a Curl decree was published. In the Curl decree, March of 33, all Jewish judges, prosecutors, and lawyers were refused access to the courts on the following day. The only exception to that was if you had fought in World War I, and as we'll see, that exemption was taken away later. So in March, if you were a Jewish judge or a prosecutor or a lawyer, you could not enter the courthouse. If that wasn't enough, on April 1st, 1933, all Jewish judges and prosecutors were suspended. So there was that officially. On April 7th, 1933, there was something called the Law for the Restoration of Professional Civil Service. Basically, that expelled all Jews from all government jobs. Also in April 1933, there was a boycott of all Jewish lawyers. So even though Jewish lawyers couldn't go to court and they were suspended, basically Germans who actually wanted to consult a Jewish lawyer were told, no, you have to boycott the Jewish lawyers. On May 10th, 1933, and you've seen pictures of this, but the important part here is it's 1933, which is the night of the book burning. And what was the purpose of that? Goebbels, who's one of the leading Nazis, said the purpose was Jewish intellectualism is dead. That was the point. In July of 1933, there was a law passed making the Nazi Party the only political party allowed, and made it a crime to maintain or form any other political party. So by July of 33, as you can see, by law, a lot of these, certainly the rights of Jews in the law and in government, were basically eliminated. Von Hindenburg died in August of 1934. Hitler became Führer, which is the leader and Reich Chancellor, and that act was ratified by a national plebiscite. You may have seen pictures of Hitler flying around Germany in this little plane. There was actually a vote, a plebiscite that made him the Führer. And then German judges began taking the oath to follow Hitler. Now I wanted to show you a picture of this because I want to point out some things. So basically what's happened here is this is the oath that the German judges are taking. You'll notice several things about this. First of all, they're of course all white males. They're taking an oath to be obedient to the Führer. They're taking an oath directly to the Führer, Adolf Hitler, and observe the law and conscientiously fulfill the duties of my office, so help me God. So I always point this out. I gave a speech about a month ago to a group of clergy, and I wanted to point out that at the end of this, they say, so help me God, if you want to have a real paradox. The other thing that's fascinating to me about this picture, among other things, is you see the pin on their lapel? You might think, oh, that's a flag, right? I mean, or that's some German national insignia. But it's not. It's the Nazi pin. So these people all had to be members of the Nazi Party, and they're swearing their allegiance to Hitler. Now this, before von Hindenburg died, the oath was different. They were swearing loyalty to the Constitution, obedience to the law. The rest of the oath is the same, but you'll see in the new oath, they took out swearing to the Constitution and replaced it with pledging obedience to the Führer. So, just want to make sure this is. So here's the thing. I'm going to take the judges later, but I like a show of hands. Of all the lawyers in Germany, how many do you think refuse to take this oath? Because the lawyers had to take this oath too, not just the judges. Lawyers, if you wanted to appear in court, wanted to practice law, you had to take the oath. When you become lawyers, you're going to all have to take an oath. So here's the oath they were required to take to the Fuhrer. How many actually seeing this oath decide, I'm not going to take it, of the lawyers? So I'm going to have a show of hands. How many think, the whole country we're talking about, how many think 10 refuse to take it? How about, we got 1. How about 5? How about 4? 3, 2, 1, 0. Okay, the answer is 1. And this is who it is. He worked as an attorney for a church, and he actually wrote, he says, I can't in good conscience swear to loyalty to the Right Chancellor and Führer Adolf Hitler. He did this in August of 1934. It was right when he was asked to do it. Now, I've given this speech to law students before, so thank God none of you are Googling right now. But in one of my speeches, somebody Googled him to find out what happened to him. And it's a remarkable story. If any of you ever want to write like a term paper or anything, this man left Germany, escaped Germany, and he went into Holland, and he worked in the underground throughout the war. And he survived the war. It's a pretty remarkable story, I think. So what happened next? I'm going to try this. I think it's going to work. Here we go. There were more executive decrees. There was more emergency legislation. All public assemblies in Germany were subject to prior police approval. So if you wanted to have an assembly, you had to get police approval. But of course, there was a condition. And if your public assembly could pose a potential threat, so all would be lawyers in the audience, could pose a potential threat to public order and security, they were all prohibited. A ban was placed on any publication, the content of which was likely to endanger public security and order. All rights under the German Constitution were suspended by law and replaced by a new law directed against, in their words, treacherous acts against the government of the national revolution. So it wasn't enough that the national government, the Reichstag and Hitler, passed all these laws. Cities then got into the act themselves. Cities themselves started proclaiming their own laws, excluding Jews from public life and all the professions. This is a picture this is early. This is March of 1933. Remember, I was telling you what was going on in March and April of 1933. This is a lawyer, Dr. Martin Siegel. Lawyers in Germany went by the doctor. So he basically was a Jewish attorney. He says in Munich, and the sign says, I'm a Jew and I will never again complain to the police. What had happened was he had a client, and he complained to the police that my client's being mistreated. And here he's walked through the streets, and you can see the brown shirts, sort of the enforcers in the early 30s of sort of the Hitler regime. Now, I do want to mention something for all the intellectual property people in the audience. These are slides that are owned by the United States Memorial Holocaust Museum, and they gave me permission to use them. I was fortunate enough to do a program with the museum and with the Judicial Council and the University of California a few years ago, and it was a really successful program. We did a program for judges on this general subject throughout the state of California, and then it was all over. I asked them for permission to use the slides, and they said, okay. So even more decrees then were issued from the Reich ministry. So you have the cities, you have the legislature, you have Hitler, and now you have the ministries, like the Ministry of Justice was the primary example. They covered everything from forbidding Jews from attending theaters and movies, expelling all Jews from German schools, freezing all Jewish property and assets, to organizing Kristallnacht in 1938. Now, Jews weren't the only people discriminated against by the Nazis. Let's be clear about that. They also officially persecuted Sino Romans, which are gypsies, Jehovah's Witnesses, the mentally and physically disabled, and homosexual persons. So the Jews weren't the only ones. These other groups were also systematically persecuted. In November of 1938, all Jewish newspapers and magazines were ordered to stop publication. All Jewish cultural activities were suspended indefinitely, and all Jewish children were ordered out of elementary schools. It became a crime for a Jew to possess a weapon. So I'm going to pause now for a personal story. This will take a couple minutes, but I just want to lay how some of these things impact real people at real times. And my mom was 16 years old and going to school in Memel, Lithuania. She was in an all-girls school. She'd been with the same girls all the way through school. The morning after Kristallnacht, she showed up for school, and the headmaster wasn't there. The headmaster had been asked to give this order and had refused, and they took him away. But the substitute headmaster said, no Jews allowed. All you girls who are Jewish, no more schooling for you in Lithuania. We're done. And so she went home, talked to her mom, and said, you know, we have to leave. We have no future here. And if I have no education, I have no future. And we need to leave. She had, at that point, 3 brothers in America already. And her mom said, you know, we have to stay. We have our house. You know, we've lived here our whole lives. You know, what do you know? You're 16 years old. And so the short version is that Mom said, no, we got to leave. Her mother said, there are a couple of conditions, one of which you get the visas, you arrange for transport, you get us to America, and we can go. At 16. So the person I call the smartest person I've ever met, at 16, got visas to America, got passage on the last passenger voyage of the Queen Mary, and came to America in 1939. So that's how it affects real people. So the next section is, look, what about the courts? What happened to the courts? What was going on there? All the way up from a new court called the Special Court, the National Socialist People's Court. There was a new court created, which the judge became the state's investigator and prosecutor. So the judge's role was not as an impartial decider. The judge's role became a prosecutor and investigator. And judges were not chosen for intelligence or impartiality or decency. They were chosen for one reason, for loyalty to the National Socialist state. That was the criterion. That's it. The judiciary's own acknowledged purpose, that is what they said their purpose was not to dispense justice, but in the words of the state prosecutor, to annihilate the enemies of National Socialism. Now, this special court had jurisdiction over Germany and all occupied territories. By 1939, according to historians, the court had become a direct tool of the state executive and completely subservient to the Gestapo. And the Gestapo itself, again, in the words of historians, never bowed to the principle of control of the police action by the courts. So what was the reaction of the judiciary to all of this? To the anti-Jewish laws, to the conduct of the police? According to Rabbi Leo Beck, who is the leader of Berlin's Jewish community, he said the universities were silent, the courts were silent. There's a historian and Pulitzer Prize winner, Saul Friedlander. He observed not one social group, not one religious community, not one scholarly institution or professional association in Germany and throughout Europe declared its solidarity with the Jews. At this point, I thought one of the things that I wanted to read, this came out of my discussions with clergy, let's say a few weeks ago. You may have heard this, you probably all have heard this before. This is a Martin Niemöller poem that it's First They Came is the title. But the story behind it is really interesting. Niemöller was a German churchman who initially supported the Nazis. He later turned against them. As a result, he was interned himself at Dachau and Sachsenhausen concentration camps from 1938 to 1945. In 1946, he wrote First They Came to express his remorse over not speaking out sooner. So this is his poem. First they came for the communists, and I did not speak out. because I was not a communist. Then they came for the trade unionists, and I did not speak out because I was not a trade unionist. Then they came for the Jews, and I did not speak out because I was not a Jew. Then they came for me, and there was no one left to speak out for me. Powerful. So in 1935, you can see there's this incremental fundamental change in the law. But in 1935, that's when, in many ways, the hammer drops. In 1935, the Nuremberg Laws were passed by the Nazi Party Congress. This is called the Reich Citizenship Law. It deprived Jews of citizenship. It limited German citizenship to persons of German, or what they call kindred blood. So this is the person who wrote the Nuremberg Laws. He's a judge, serious-looking fellow. He was a state secretary also. They blurred the lines between the judiciary and who was in the ministry. And he says, those actions of judges that seek to limit the political decisions of the Fuhrer are direct opposition to the central legal conception of the National Socialist State, namely the Fuhrer principle. So there are two big takeaways from this. One is, there goes independence of the judiciary, right? We talked about independence from political forces. What he's saying is there's only one person that matters, and that's the Fuhrer. And the Fuhrer principle, as we'll see later, is what they call all this. That's the sort of legal description. Fuhrer principle is the Fuhrer knows everything, the Fuhrer's in charge of everything, the Fuhrer orders everybody else around. So I want to talk about the Nuremberg Laws, but under these Nuremberg Laws, I want you to know the effect of them. All the voting rights of Jews were canceled. All of the legal rights were canceled. At that point, remember I told you there was this decree that accepted Jews who'd fought in World War I on Germany's side. There was a decree in 1935 that said, okay, we're done with that. All Jewish professors, teachers, physicians, lawyers, notaries, you're all dismissed, no matter what your service to Germany was in World War I. Now, remember in the oath it said, I'll be obedient to the law. And of course, after World War II, the judges said, look, I followed my oath. I was obedient to the law. I followed the law. That's all I did. I wasn't aggressive in interpreting the law. I just followed the law. So I'm going to use one example of one case to show you how that's just not true. Now, these laws prohibited intermarriage and extramarital relations between Jews and non-Jews. The penalty ultimately was death for the Jew. And all laws, of course, were enforced by the police. The judiciary and judges fully cooperated in these actions against the Jews. And then I want to talk about this one decision by the German Supreme Court in December of 1936. So they had to enforce these Nuremberg Laws, right? And they had to decide sort of what do these laws mean. Now, they said, well, one of the things that prohibits is extramarital relations between Jews and the subjects of the state of Germany or related blood. So what do extramarital relations mean? There was a government ordinance that said extramarital relations means sexual relations. That's how we're going to define it. So all of you that are going through statutory interpretation classes and these principles, all right, so now you've got a big law that says extramarital relations. You've got sort of an interpretation of that in an ordinance that says it means sexual relations. So the Supreme Court was asked to define what that meant in a real case. They said, you know, that decision is really left for the courts to decide. So let me ask you some questions. Those are that's all you got. Extramarital relations, sexual relations. So by show of hands, how many people think that sexual relations require bodily contact? Pretty much unanimous, right? So that's the question before the German Supreme Court. This group of judges say, all we do, we just follow the law. We're not really aggressive. So this is kind of what they're faced with. They say, well, you know, we got this preamble to the Nuremberg Laws. It talks about the purity of German blood. It's really essential. This is the law. Extramarital relations are forbidden. So this is how they start out. This is a real opinion. And by the way, when you read this opinion, you look at it, it's going to look really familiar to you in format. Because it's going to talk about the facts. It's going to talk about the law. It's going to talk about the purpose of the law. Sounding familiar to you? It's going to talk about the text of the law. Then it's going to apply the law to the facts. And then there's going to be a conclusion. That's just just what they do. So this is what they say. They say, you know, we really don't want a narrow definition of sexual relations, equating with intercourse. We don't want to do that because it would pose nearly insurmountable difficulties for the courts in obtaining evidence and force the discussion of the most delicate questions. So in other words, they don't want to look at evidence, basically. It would be really difficult. A wider interpretation is required here because the provisions of the law serve not only to protect German blood, but also to protect German honor. So now they're getting in, that's the purpose of the law, so now we're going to decide how we're going to interpret this law. And so this is what they decide. They say any act that satisfies the sex urge violates law. The crime is established even if the sexual act occurred abroad. Intent was irrelevant in determining penalties. A verbal proposition for sex violated the law. And you were all correct, you know, I guess. They decided the crime did not require bodily contact. So basically, sexual relations requires no bodily contact. So these are judges who say it after the war, hey, we were just reading the law. We just applied the law. I think that's just absolutely false. So by 1942, the German Ministry of Justice announced that the Führer, by this time, remember, the war starts in 1939. By 1942, the 42 is the year that at the Wannsee Conference where the final solution is determined. So by 42, they just say, look, the Führer has the right to intervene in all judicial rulings over and above any formal arrangements. In other words, the Führer just can decide any case. From late 1942, Jews were not subject to the jurisdiction of the courts at all because they were deemed to be inferior people not worthy of the rule of law. So the question, I asked several questions. The first question was, what was the rationale of the judiciary? I mean, what were they thinking, right? And there's a lot of historical work on this. So I'm going to go through some of it with you. I want to say, what was the underlying rationale of the judiciary? What was being published at the time, and what do historians think about it? So one scholar said there were essentially three principles that were held to be axiomatic for the entire field of administration, as well as the judiciary. First, the principle of absolute rule by the leader, which is the Führer principle. Second, the principle of authority of the party, that is the Nazi party, over the state. And third, influence of race as the fundamental principle guiding affairs of state, essentially racial inequality. Another historian agrees with this and says the purpose of the law in the eyes of the Nazis was not to apply long-held principles of fairness and justice, but to root out the enemies of the state and to express the true racial feelings of the people. According to an historian, the first and foremost task of the judiciary was to subordinate itself to the totalitarian will of National Socialism. So what about individual judges? We've observed the coordination of the entire judiciary. What was the role of individual judges? According to one author, the German legal profession, above all judges, had fully succumbed to the power of corruption, not in the material sense, but in the ethical sense. As he described, judges entered a moral abyss. Okay, so now we get to the next question. How many judges do you think resigned? Either because they didn't want to take the oath, or once they saw what was happening, decided, I just can't take this. This is just wrong. You have thousands of judges. So, okay, we'll do this again. I'll start at 5 because you're already getting the picture. How many people think 5 people resign? Okay, 4, 3, 2, 1, 0. Okay, there are a lot of winners. There's one really comprehensive study, and this is what the conclusion was. Not a single judge appears to have resigned in protest. Not one. Now, I really tried. I started reading all these books to try to find somebody who did something to protest the acts of the Nazis or coordination of the judiciary. So I found one judge who complained about the treatment of the mentally ill really early on. He wrote a letter saying it's an injustice masquerading in the form of law. He was allowed to quietly retire in 1940 with a full pension. So I don't know if you want to count him or not. He retired, he got a full pension, but at least he said, I don't want to be a part of this. That's pretty much in the official records. There's some magazine article about a woman who obviously loved her father and said that my dad was a judge and he, in Marburg, Germany, and he was a judge and he refused to join the Nazi party, so they fired him. And he had to work as a messenger. And that's it. It's whether the number is resigned or retired is 0, 1, or maybe 2, it's meager. The German judges who continued to perform their jobs without question obviously did the work of the Nazis. The president of the court, that is the head person, declared the German judicial system can take pride in being the first branch of government in the Third Reich to carry out in its personnel policies throughout the Reich and at all levels of civil service the principle that the movement, the people, and the state are one. So scholars agree that the judiciary largely contributed to its own demise. In particular, they say it actually promoted its own takeover by close cooperation with the police. And all these historians agree that the judiciary cooperated with the Nazis with zeal. A question that's obviously asked then is why, right? Why did the German judges so willingly coordinate themselves in the Nazi system and enforce this doctrine? So again, I went back to the historians. One key scholar says, as Nazis, they actually believed that a state was not only empowered, but actually obliged to override individual rights in the interest of creating an ethnically homogeneous nation. They believed it. There's a historian, Claudia Kuntz, who I think is, of the historians I've read on this subject of the sort of the analytical psychology, sociology of this, I think she's the best. So the Nazis denounced the idea of universal human rights, saying not every being with a human face is human. As she describes, this belief expressed the bedrock of Nazi morality. Remember, she's calling this morality. That's the title of her book. The morality was a combination of biological theories and racial passions, racist passions. Kuntz powerfully wrote, ethnic Germans were exhorted to expunge citizens deemed alien and to ally themselves only with people sanctioned as racially valuable. The road to Auschwitz, she wrote, was paved with righteousness. So her explanation joins many other theories on why Nazi civil servants and judges coordinated themselves with the Nazi system. Why would many of the same people who were judges before Hitler make decisions later according to Nazi doctrine? Were their actions driven by nationalism or by racial pride? Were they concerned their careers were threatened? Did they seek to advance their own careers? Were they afraid of the Nazis for the safety of themselves and their families? Were they just following orders? German judges after the war, as we discussed, claimed that they were victims too, and they were just following the law. Those judges argued they did not have the power of judicial review of executive or legislative acts, and their only job was to follow and interpret the law. So I've been really fortunate in my life, and one of the big blessings I've had is I had several long conversations with Nobel Peace Prize laureate Professor Elie Wiesel, and we talked about the German judges. He was very well, as in every subject, but he was well versed on this one too. And he said that the German judges ignored the impact of their decisions on individual people and demonstrated, in his words, a total absence of humanity. He observed, too, that they lack courage. But this goes to the empathy and lack of common decency that I talked about. So whatever the reason or combination of reasons, it's manifestly true that the German judges coordinated themselves into the Nazi system and were ethically corrupt. As succinctly stated by a leading scholar, the principle of the rule of law is not compatible with that of authoritarian leadership. As she observed, judges became immediately answerable to the Fuhrer. This reality represented the climax of the destruction of judicial independence. So I told you that I wanted to give you a bonus. So I'm going to talk about the Nuremberg Trials a little bit to put some justice into this. So between 1945 and 1949, the American, the British, the French, and the Soviets indicted and tried over 200 former Nazis in occupied Germany. So why was Nuremberg chosen? Why was the city of Nuremberg chosen to be there? There were two reasons, fundamentally. One was symbolic. That is that this is where the Nazi Party Congress was held in Nuremberg. This is where the Nazi Party rallies were held in Nuremberg. This is a picture of one of the rallies in Nuremberg. So it's symbolic. Here's the home of the Nuremberg Laws. Here's the Nazi Party Congress. This is where every year they have these huge rallies. They had military people, but they also had children, and they had just all sorts of pageantry to honor the Nazis. The other reason was practical, and that's a palace of justice. So it had the city of Nuremberg, if you've seen post-war pictures, is pretty much destroyed. But this remained. And it's important because in the Palace of Justice, there's a courtroom, a functioning courtroom, and there's a prison. So there's a courtroom in the front and a prison in the back. So the prisoners could be taken from where they were to the courtroom very, very easily. So it was symbolic and extraordinarily practical. I should tell you, I had the privilege of speaking in the courtroom at the 70th anniversary, which was in 2015. So I got to give a speech in the courtroom 600. It was kind of an out-of-body experience. It's pretty amazing. So what about the Nuremberg trial? So there's one main Nuremberg trial that people think about when they hear about the Nuremberg trial. This began on November 20th, 1945, shortly after the conclusion of the war in Europe. It was a trial of the 21 major war criminals before an international military tribunal. So this is a military tribunal. The trial lasted 217 days. There were 240 witnesses, 300,000 sworn declarations, and 2,630 documents were entered into evidence. This is all without computers. Think about it. Think about how this team of lawyers had to put all this together. It was also the first time there was simultaneous translation of languages. First time in history. So I want to show you some slides here so you're familiar with some of the people. So one of the heroes of all this is Justice Robert Jackson. He was a justice on the United States Supreme Court. He was chosen by President Truman to come to Nuremberg and be the chief prosecutor on the American team. And he organized all this, all those documents, all these teams, all these people trying these 21 major war criminals. He was the former Solicitor General of the United States. He was also the former U.S. Attorney. And as you start, wherever you are in law school, you either have or will read Korematsu, the Korematsu decision. Justice Jackson dissented in Korematsu. And I'm going to close this with a quote from a Jackson opinion, which I think epitomizes all that's best with American jurisprudence. So he was the right person for this job. Who were the defendants? Well, first of all, here's a picture of Jackson right over here. He's delivering one of the arguments. You can see the judges are British, French, Russian, and American. See all the paper. They basically, the big Nuremberg trial was tried basically on documents. There were very few witnesses other than the defendants themselves. the decision was, we're going to try you on your own writings, because the Nazis took meticulous records of what they did. These are the defendants. Goering is the one who's sitting up, sort of the leader, who's sitting in the military uniform. And then this is they're all in the dock. They had rights in this trial, which I think is important. All but 3 were convicted, with sentences ranging from death to a term of years. Also, it was unusual because not only were the individuals convicted, but the organizations were convicted. The SS was convicted, the Gestapo was convicted. So that if later on, in a later trial, somebody was a member of the SS, that was an automatic conviction, because the SS had been deemed a criminal organization. Now, so what I wanted to talk about were trials, if you get nothing else out of the Nuremberg trial part here, there were trials after the main Nuremberg trial. There were subsequent trials. There were 12 trials. And I want to go through them because I think it's really important to see who was tried. These are trials by the Americans. So this is in the American zone in Nuremberg, tried by American prosecutors, and the judges were American state court judges. That's who, because the British and the French and the Russians had left. They had the main trial, they were gone. Now just the Americans remained, and the state court judges from all over the United States were the judges, and the Americans were the prosecutors. So these are the people they tried. They tried doctors who performed experiments on concentration camp inmates. They tried the perpetrators of slave labor. One of the things that Nazis did is they took people from all these countries and made slaves out of them. And there was a ton of slave labor throughout Germany and the occupied countries. They tried members of the SS elite guard who conducted genocide. In one of the most important trials, they tried the SS Einsatzgruppen. These are 23 military officers who were in charge of killing squads who murdered over 2 million civilians. As they advanced through Eastern Europe and into Russia, the Einsatzgruppen, you've seen pictures of this, where they lined up people in pits, they had them dig their own graves, and then they murdered men, women, and children in point blank, cold blood. Right? So they killed 2 million of these people. Now, one of the harrowing thoughts about the Einsatzgruppen is, remember I told you there were 23? Most of them had legal educations. Most of these military leaders who were the leaders that were convicted at Nuremberg, had legal educations. Industrialists were tried, and then military leaders were tried for the deaths of POWs and civilian hostages. So the movie Judgment at Nuremberg, which, here's a poster. I showed this in my law school class because I was telling Dean Salcido a little bit about this before. So the stars of this movie are Spencer Tracy, Burt Lancaster, Richard Widmark, Alina Dietrich, Judy Garland, Maximilian Schell, Montgomery Clift. These are all these are the A-team at the time. But in my law school class, when I ask, I won't embarrass you, but when I go around the room and I say, who knows these people? Basically, I get Judy Garland, And it's like, who's Burt Lancaster? Who in the heck is Spencer Tracy? But anyway, I'm gonna give you all credit that you all know who these people are. But this is a movie about the trial of the judges. And what it dramatized was the trial of 14 German judges, prosecutors, and members of the Ministry of Justice charged with war crimes and crimes against humanity through the abuse of the judicial process and the administration of justice. The major prosecutor of this trial was a general named Telford Taylor, and he said the dagger of the assassin was concealed beneath the robe of the jurist. That was his famous quote. Now, I don't know, I mean, you've seen it, but 60 Minutes, probably within the last year, did a story, Leslie Stahl did a story on Ben Ferencz, who was the youngest American prosecutor. He's now in his 90s and still full of vigor. And he basically found these books that the Einsatzgruppen kept of who they killed, when they killed, how many they killed, where they killed, everything in detail. And he found all this, and he went to tell for Taylor, and he said, we have to try these people. I mean, we have all the evidence. It's right here. They have their own records. We have their records. And Taylor said, well, you don't have the people to do it. And Ben Friends is right out of law school. I mean, this is a guy who had no trial experience, nothing. And he said, well, I'll try it. He says, well, you have to try it on your own time because you have to do all the regular work and then you've got to try this case. And Ben Friends said, I'll do it. So he was the lead prosecutor in the trial of the Einsatz group, and it's a remarkable story. He convicted all of them, of course. So I want to talk about one aspect of the trial. Now, the movie Judgment at Nuremberg is actually patterned after a real case. The real case is called the Katzenberger case. Leo Katzenberger was a merchant in Nuremberg. He owned an apartment building. There's a woman in the apartment building who was the daughter of a friend of his. The friend said, hey, please take care of my daughter. The daughter's married, but you know, it's wartime, please take care of my daughter. So he did, and they became friends. And then Katzenberger was arrested for, you guessed it, violation of extramarital relations and sexual relations with this woman. And they had a real trial. And, you know, the evidence basically was, he said, yes, we greeted each other with a kiss, we hugged, we were friends, no sex. She says, no sex. We're friends. We hugged each other affectionately when we saw each other. That's it. So there's a whole written opinion by this Judge Rothag, who, by the way, got life imprisonment. His sentence was computed at 20 years. But basically, what he wrote was, look, we have this decision by the German Supreme Court in 1936. It says what it says, which is you don't need bodily contact. And we know that Katzenberger must have been attracted to this Aryan woman, and we know there must have been sexual relations. We just got to know it. And relying on the 1936 German Supreme Court decision, Leo Katzenberger is convicted, he's sentenced to death, and he's executed. And the woman was sentenced to, she was deprived of her citizenship for a year and sentenced to hard labor. So the movie Judgment at Nuremberg ends, is this really dramatic scene, which is easily the last, is the last line of the movie, is the best line in the movie, and it really captures the message, I think, of the failure of the judges. And Burt Lancaster plays the judge who's been convicted. And, you know, totally unrealistic. He's repentant, and he's sorry, and he tells the judge, Spencer Tracy, you know, I didn't think it would come to this. In other words, I didn't think by doing what I did would lead to the death of millions of people and the destruction of you. And Spencer Tracy looks at him and says, it came to this. The first time you sentenced a man to death, you knew to be innocent. And that's how the movie ends. It's really very powerful screenwriting. So I try to decide how to end, I try to end these things on somewhat of an uplifting note, which is kind of hard to do. So I had the same issue when I was giving the speech in Courtroom 600. Like, how do I end this on some sort of an optimistic note? So I went back to Justice Jackson. Before he went to Nuremberg, at the same time he wrote his dissent in Korematsu, he wrote a case called Board of Education versus Barnett. The background of this case is pretty simple. There was a case called Gobaitis, which had the same facts, actually, as Barnett. It was decided by the U.S. Supreme Court in the early 40s. And in Gobaitis, what happened was there was a law that said that everyone had to salute the flag, every student had to salute the flag in school. And if you didn't salute the flag, then you were subject to expulsion, And then, of course, you weren't going to school, so your parents were then committing a crime of not having a student in school. So you don't salute the flag, this is the consequences. So in Gobaitis, the United States Supreme Court was presented with the issue of, can a state do that? Can a state order its citizens to salute the flag? Remember, we're in the middle of World War II. By the way, I'm not going to do it, but the salute that they were ordered to do is very reminiscent of the Nazi salute. That was where their hands were supposed to be. Instead of pointing up, instead of pointing down, they were pointing up, but it was essentially the same salute. And in Gobaitis, the United States Supreme Court said, that's okay. State can do that, state can order this, state can exact these punishments if you don't comply. Jackson joins the court. Jackson goes to the other members of the court and said, this is an abomination. We have people fighting for freedom, for liberty, and you're going to have a law that says you have to salute the flag on. Now, you should salute the flag, he said, but not be compelled to do so. And so he persuades them the next term to take Barnett, which is the same issue that they just decided in Gobaitis. It's unheard of. They take Barnett, and they completely flip. And they decide, no, the state does not have that power. The state can't tell you what religion to practice and what beliefs to have. And of course, the complaining people here were Jehovah's Witnesses. The Jehovah's Witnesses said, in our religion, we regard the flag as just an object, and we do not salute objects. We pray to God. We don't salute or give tribute to objects. And the flag is an object that offends our religion. We're not going to do it. So it was a religious objection. And so Barnett said, no, you can't be compelled to give the salute. And what he wrote is really inspirational and aspirational at the same time. So I'm going to read I'll give you the whole opinion. We'll be here for a while. We won't have time for questions. So I'm going to read 2 paragraphs. And that'll be what I'll conclude with, and then I'd be happy to take your questions. So what he said was, the very purpose of the Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. One's right to life, liberty, and property, to free speech, a free press, freedom of worship and assembly, and other fundamental rights may not be submitted to vote. They depend on the outcome of no elections. And he concluded with a line that has been quoted by the United States Supreme Court as recently as 2013. Basically, Chief Justice Roberts said, I can't do better than this. And he concluded with this: if there's any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. If there are any circumstances which permit an exception, they do not now occur to us. Powerful words. Thank you very much. Thank you. So we have
Questions, go ahead and ask them to the center aisle. I have one good one that I think I'll start with, and then I can. So this person asks, has your study of the Nazi judiciary given you any insight into how to inoculate the U.S. judiciary against political influence at a time when, and I'm adding this, it appears that membership in the Federalist Society is a precondition for appointment? Tough question.
Yeah, thanks a lot. Okay, well, there's really a lot of questions in a single question. So let me take the obvious, which is elections have consequences in the United States. And is pretty, the person who's not president before he was elected, running for president, said, I'm getting this list from the Heritage Society and from the Federalist Society, and I'm going to choose my judges from this list. Couldn't have been any clearer than that. So the answer is yes. He is, I think every judge that this president's appointed has been from that list. And the whole way that judges are being chosen, federal judges, remember again, we're talking about federal judges on circuit courts and on federal district courts throughout the United States. I think it is a fair statement. What you will see, what you have seen, and what you will see are judges who are appointed from the Federal Society and from the Heritage Society, sort of list of approved judges. So that is a true statement. In terms of inoculating judges and talking to judges, there are several things that are happening. Both, I mean, I'm very familiar with the state code of judicial ethics because I helped write it. The feds have their own code of ethics, except for the U.S. Supreme Court that doesn't. Very consistent. The federal code of judicial ethics is based on the ABA code, and the principles in the ABA code are very similar to the principles in the California code of judicial ethics. And they emphasize the things we talked about, which is impartiality, independence from politics, and decisions free of bias and discrimination. And these programs that I talked about that were done on the Nazi legal system were done throughout California. You're going to get booklets. The United States Memorial Holocaust Museum, this is a version, I think they just came out with a new version. This is essentially the same. They gave to me these some time ago, but you'll get them. And judges get these too. The United States Memorial Holocaust Museum has a whole program on law and justice and about the German legal system. And this class is taught by museum staff throughout the United States to judges, both federal and state. And in California, like I said, we have taught this class throughout the state. So they are getting these principles. But there is a reality. I mean, the reality is that, in California, except for some exceptions for elections, the governor appoints judges, and in the federal system, the president appoints judges. And they're going to typically appoint judges who they think have a jurisprudence that they want.
These are all good.
Okay.
I think when you turn the tables, they make them really good questions. The next one is there evidence that Hitler had a comprehensive legal plan for takeover, or did it appear to be more ad hoc?
Well, this is more of a historical question, so there are probably some history professors. But, he wrote Mein Kampf, right, in the 20s, and had laid out a pretty straightforward plan of what his objective was. He had, the Nazi Party was a minority party. They exercised their will through violence, the brown shirts, through intimidation. He certainly had a plan that dated back a decade for takeover of the government. He had, his platform, if you will, was, we lost World War I. It wasn't our fault. It was the fault of the Jews and the other people. And all your troubles can be solved if you just, make me Führer, and I will, build the roads and make everything run on time. So I don't think it was ad hoc, in my own opinion.
What do you think is triggering the reemergence of neo-Nazis, and how has the current presidential administration contributed or maybe affected this?
Okay, so I'm not supposed to get into politics, but let me make a general statement. Let me just say from a personal standpoint, I never thought I would see in America what happened in Charlottesville. I never thought I would see Nazis marching. I just never, and getting the attention they got and not getting the opprobrium they deserve from many quarters. Before I get to the bad stuff, I will say the good stuff. Remember I talked about, I did this on purpose, In the very beginning, I talked about how all the major institutions in Germany failed. The press, the legislature, the judges, the universities. They all failed. One thing after Charlottesville which I looked for and saw, was that's not what happened here. The university spoke up, lawyers spoke up, law schools, the press, businesses which maybe not intuitively for a lot of us, businesses stood up. So all these institutions stood up and said, this is wrong, and we have to do something about it. I'm not going to say, I think President George W. Bush, a week ago or two, said it seems like these extremists, are somehow emboldened in the present time more than they have been in the past. I think that's pretty obvious. I don't think I'm saying anything controversial with that. I'm grateful that the major difference that I see is that these institutions have really risen up. You get these, not just open letters, you get people resigning from committees, you get editorials in the press. People are not going along with this. They're saying this is wrong. This is scary stuff. These people are delivering a message of hate, and it's not just the ADL, who's saying this. It's or the Wiesenthal Center or something like that. It's a very broad-based opposition to this, which to me, I was looking for this, and I was encouraged to see it.
So this question's a little different. During the follow-up Nuremberg trials, why was the United States the prosecutors? Shouldn't it have been international courts?
Well, there were trials in other zones. The American zone was the primary one, but the Russians had trials, but theirs were show trials. The French had some, and the British had some. But again, it was in Nuremberg. Nuremberg was in the American zone. There's a whole big controversy in the beginning. Berlin was in the Russian zone, and so the Russians wanted to hold the Nuremberg trials in Berlin. And the Americans said, no, we got the whole thing going here in Nuremberg. So they actually had, I think, the opening session, like call to order, in Berlin. That was sort of the compromise, and then they all went to Nuremberg. But the reason is very simple, and that is the Americans were really invested in this, and they wanted real trials. They wanted to bring some of these horrible people to justice, and they felt they had an overwhelming amount of evidence that was in large part created by the Nazis. But that's why. I mean, it was a will to do it. There was a big debate about whether to have the Nuremberg trial at all, as you probably all know. That the Russians wanted basically to line up leaders and to shoot them. Or short of that, just to have show trials, which is what the Russians were doing. The British, Churchill had a famous quote. He said, what I really want to have happen is there'd be an incident. We line up 50,000 of the top people, and there'll just be an incident. And then the Americans were the ones, the Secretary of War Stinson was the one, and Morgenthau went to Truman, and basically, because Roosevelt had died, so Truman became president. And they went to Truman and said, we have this opportunity to make a record for generations to come. And we don't want to do victor's justice. They're going to say it's victor's justice anyway, but let's do it the right way and have a real trial. And they had rights to, they had right to counsel of their own choosing, free. They had a right to cross-examine. They had a lot of fundamental rights that obviously they didn't give to any of their victims. But they had a lot of rights that was not a show trial. And some of them were acquitted. I mean, just so you know, the Russian judge voted death for everybody. But the way it worked, it had to be unanimous. So basically a lot of them were just in term of years, and 3 were acquitted. There's one person who just got there by mistake. There's one defendant who nobody really understood why he was there, except the Russians really wanted him there. So they said, we got to have him there. So again, it was a compromise. But there was no evidence that tied him in. Someone said, you had all these major players like Goring, and then you had this one guy who just didn't fit. He was a very low-level person who didn't really have any authority at all. Yes?
Was there any attempt by the legal profession to challenge the Enabling Act of March 1933?
None. I can tell you that one of the things, and again, I don't want to be flippant about this, because again, you have to kind of bring yourself back to the time. This is not an excuse, it's just an explanation. But remember, they opened Dachau. Dachau was not opened as an extermination camp for Jews. Dachau was open as a camp for political prisoners, for anyone who objected to the politics of Hitler. So Dachau was populated basically by German intellectuals, clergy, anybody who objected to the Nazis. So it's not an excuse for not objecting. It's just, I think people felt if you objected to the Enabling Act, you were going to Dachau. And that's what happened.
So I think we've learned a lot of lessons, especially how quickly these things occurred.
Yeah.
This question says, are there any other insights from fascist regimes that similar legal systems or histories under Mussolini, Pinochet that?
Yeah, I mean, I think, again, there's probably more historical scholars in this audience better than me, but than I, whatever. Yeah, there's certainly commonality when you look at this. There's, a strong leader who wants to be dictator. There's the support of the military. That's crucial to all of these things. Hitler had the Gestapo, the SS. He had the power. He had the military terror behind him. Those two things, I think, are really crucial, because when you have an authoritarian leader, plus you have the police or the military behind you, that makes it very easy, not an easy road, but a clear road. And it's interesting that sort of the side thing for the military, Hitler, remember, military in Germany, it was a very strong military in terms of their esprit de corps and their education and all this kind of stuff. And basically Hitler went to them and said, look, if you support me, I will support you. I'm going to build up your armaments. I know after World War I we were supposed not to have an army, and we're supposed to have not that much military might. But if you support me, I will support you. So if you just, pledge me your allegiance, then I'll make sure you get all the armaments and all the support and all the funds that you need. So there was a real deal there that was made. That was one of the beginnings of the end. There's one thing the other brown shirts were this kind of, hooligans, basically. It's another thing that turned it into the SS and the Gestapo, and then had the military back everybody up. That's what I think, if you look at the question was, there's something in common that a lot of these dictatorships have. That's, to me, that's what it is. And of course, it's so that by backdrop, that the institutions are not standing up. The universities, the press, that kind of thing. No, the professions, nobody's standing up.
This is a question about judging.
Yeah.
How do you balance empathy and self-protection? So I'm interpreting it maybe.
I think I get it. I get it. I think let me tell you, whoever asked the question, this is the question. This is an important point. So here's the hypothetical. You have a defendant in front of you, right? Let's just take the worst case. Committed a murder, right? So there's a defendant, and then you've got the victims, the victim family. Think about it. So what I mean by empathy is not sympathy. Empathy is, I understand who you are, I understand where you're coming from. I can put myself in your place. It's not a sympathy thing. It's just, I understand which is something the German judges never did by way of making a point. They never said, I'm sending you to death for really nothing, being a friend with someone who's an Aryan and you're Jewish. It was never a thought process of, that's really unfair if I think about it. Okay, so you're speaking to a person, yeah, I'm responsible for sending a lot of people to prison in their sentence and affirming sentences in prison for very long periods of time. So how does empathy relate to that? Empathy relates to that is, I look at the whole picture, I understand the victims, I understand the victim's family, I understand, in many cases, if somebody had a really messed up childhood and had a mental illness maybe drugs, you feel for the people, but having said that, you still have to follow the law and do justice. Now, there's a lot of discretion in some cases the judges have on sentencing. So you try to exercise that discretion in a way that's fair to everybody. But you have to the point is you got to be able to put yourself in everybody else's spot and then try to make a decision that's under the law and does justice. So yeah, it's a difficult job if you do it right.
And I think on that, there are other questions, and I know people will probably want to talk to you in person, so can we give Justice Fybel?
Okay, thank you.